No, no,
That doesn't get any better for them.
yes, I know. Maybe you misunderstood me. I didn't say after 9 March 2019, the appointment became lawful. No. What I was saying is that after 9 March 2019, your client could no longer say the appointment is unlawful because it doesn't comply with Section 54. The reason being that Section 54 has ceased to exist. That's the point, the narrow point that I was making. And therefore, I'm trying to determine when we get to remedy, what is the relevant period? Is it from the date of appointments that are impugned until the 9th of March? Because I don't see on what legal basis can we go beyond the 9th of March, unless I'm missing something.
Well, with respect, I think that you could enforce this illegality or enforce a remedy in respect of the illegality after the 9th of March. Otherwise, you end up with the anomalous situation that before the 9th of March, one can't remove a person who was illegally appointed. Or after the 9th of March, you can't remove him, whereas before the 9th of March, you could remove him. Surely, if something is illegal according to law, it can be enforced at any time in the future, as long as it happened during the existence of the law.
Yes, no, again, I think we're missing each other, but I think we are on the same page.
Yes, yes.
You can pursue the claim, but in relation to the period when the law that you rely on was still in force. You can't say when the law is no longer in force, it is unlawful because it doesn't comply with that law, can you?
Well, that's exactly what I am saying, because I'm afraid we just we'll have to differ with each other.
Yes, yes, but I accept that. I don't remember now. Maybe you can clarify it for me. I looked at some and I didn't pick up the recording of the order that was granted by the High Court in declaring the section invalid. Remember, in some we confirmed that declaration of invalidity.
Yes.
So I'm not sure whether the High Court in itself had dealt with the issue of retrospectivity. But in our judgment in SAMU, we say the order will operate prospectively. But in the order itself, we don't deal with the retrospective operation.
Yes, I think that's correct. But that's why I went to some pains to set out the various authorities that deal with how one reads a judgment in relation to suspension and retrospectivity and so on. And my submission is that what the Constitutional Court did on the, I think it was on the 9th of March 2017, is suspend the declaration of invalidity for a period of 24 months to allow the legislature to correct the defect. Well, unfortunately, they didn't, certainly for those parties that would like them to have carried on. But that means that after 24 months, the suspension falls away, the declaration of invalidity comes into effect, But that doesn't affect, just to go back to our earlier discussion, that doesn't affect anything that happened before the declaration came into effect.
Okay.
I can't answer your question about the...
Yes, yes, I understand.
I do recall having taken attention to it at one stage, but I thought that as the Constitutional Court had made its own order of suspension, that I could forget about that.
Okay. And lastly, it seems to me, and correct me if I'm wrong, that the SCA was split on the basis on which the majority supported the order. As I recall, Justice Mulemela and Justice Zlati Oyo based their conclusion, insofar as the delay is concerned,
Yes.
based their conclusion on the fact that this was a Paja review.
I think that that's a fair assumption of a reading of it, because if you find, as they did, that it doesn't matter whether it's Paja or a legality review, then you've more or less decided that it's 6 months, 180 days, and not a reasonable time, because to find that it's not important to decide whether it's the one or the other really avoids the main topic of discussion, and that is, how long do we have?
Yes, exactly.
Yes.
That's my point. That's the difficulty that I have.
I agree with you. Yes.
Justice Mahoka held that it was a legality review, and therefore the test was whether or not the delay was unreasonable.
Yes, and
they said no, it was reasonable, because there was an explanation. You had to look at the provisions of Section 41 that says when the dispute is between organs of state, they should try to resolve it before they go to court, and going to court would be the last resort.
Yes, that's
now,
correct.
I'm not quite sure. What do we make of that? How do we come to the conclusion that there was a majority finding relating to delay? Because Justice Mahoga says, on the merits, these guys should not have been appointed.
Yes, but he said the delay was inordinate.
Yeah,
and that the MEC should be ashamed of herself.
Yeah.
Well,
yeah,
that was his finding. So his judgment on that, the single judgment, taken together with Justices Molamela and Puad Lawati, it's 3-2 split on the fact that the reasonableness was excessive. Sorry, the delay was excessive.
Yes, no, but the problem is that you have the 2 and 1 not agreeing on the basis of, the delay being unreasonable.
Yes.
How do we deal with it?
It is complex, because if you accept that Justices Molamela and Puad Lawati were dealing with a Paja review, which it can't be, for all the reasons that I've set out already. Yeah. But if you accept that that's what they thought, then it was clearly after 180 days. There was no application for condemnation, and therefore it was an unreasonable delay. It was actually a critical delay, because it fell outside the 180 days. Justice Makoka, as I understand it, regarded it as a legality review. Therefore, he's judging it on the standard of a reasonable time, and he felt that the delay was excessive.
Yes.
So they are saying different things, and maybe it's not 3-2. Maybe it's 2-2-1.
Yeah, all right. Thank you, Mr. Dixon.
Thank you, Justice Jefter.
Mr. Dixon, my brother Justice
Mablanga, yes.
Yes, my brother Justice Jefter was interested in the intervening 19-day period between the date of the High Court judgment and the terminal point of suspension.
Yes.
In terms of the SAMU judgment. Let us forget for a moment the possible complication that may arise from the fact that our order says nothing about prospectivity, even though the judgment itself does say that the declaration of invalidity is to be prospective. Let's forget that and work on the basis that the declaration was indeed prospective. And an issue that comes to my mind, there may well be a judgment of this court, but I'm not aware off the top of my head, and I want your assistance. My brother Justice Jefter touched on the principle of objective constitutional invalidity, where, for example, absent a declaration that the declaration will be prospective, ordinarily in terms of this principle, the statute will be invalid from the date of the coming into effect of the Constitution if the Act predates the Constitution, or from the date of the Act if the Act took effect after the coming into operation of the Constitution. That's not where my interest is, but my interest still relates to the principle of objective invalidity. Now, but the focal point here being, you have a declaration of invalidity, but it is prospective, not retrospective. And then there is a suspension, say for 2 years, as was the case in Samoa. Then the period of suspension comes to an end, and the legislature has not done anything. What happens there? Does the declaration of invalidity take effect from the date of the order, or what happens exactly? I'm asking this because it may have relevance to what we should or should not do in this matter, or what we are able to do and what we are not able to do.
Yes. Well, Justice Madlanga, that is it is one of the interesting questions about the SAMU part of this case. And I've made fairly detailed submissions about it. And I think that despite the fact that Justice Jefter didn't like my examples of the All-Pay case, the All-Pay case kept alive an invalid contract over 3 or 4 different hearings. And I've set them all out in in 614, paragraph 614. So the examples are there of something that's unlawful and illegal being given legality for a particular period. Now, if I could just take the facts of the case, the loser of the case, Cash Paymaster Services, the service provider, they were allowed to continue their illegal service until the next hearing. They then had that illegal service continued again. But when eventually the date comes where their illegal service stops, you don't go back and look from the beginning and say, well, all of that service that Cash Paymaster Services rendered was illegal. We gave it the nod of of a suspension to keep it going, but in fact it's illegal. Now that would be absurd. That would be an illogicality, because this court is allowing them, based on just and equity, allowing them to continue despite the fact that their contract was illegal. In this case, we are dealing with two different times of fixing. The first is that if you appoint someone who doesn't have qualifications, that contract is null and void. So that's the time at which it operates. So if you appoint a municipal manager who doesn't have qualifications, it's null and void. But it requires the MEC to go to court to get a declaratory order that it was null and void, and then the court does the Section 172 operation of deciding whether it's fair and equitable to everybody, and in particular the municipal managers, as to when they fix the date by which time or at which time that person must leave office. Now, we've had a number of situations in this case. The High Court said that they couldn't backdate it. These people had done the service. It would mean them having to pay back their salaries and so on. So it quite fairly said it's going to work from the date of the order. Then, of course, you go and appeal it. That complicates it. The part of the court in the Supreme Court of Appeal, that's Justice Ponnen and Justice Zondi, said that I had agreed with them that there should be no order and it should just run till the end of their contracts. Well, we did have that discussion, but I don't recall ever agreeing to that, because what I said to the Supreme Court of Appeal is that it would mean that they would then be endorsing an illegality. Now we are here on an application for leave to appeal to the Constitutional Court, and we have made submissions that in fact we can't ask for it to be retrospective. We would only ask for it to be declared illegal from the date that the court grants judgment. These municipal managers, if I'm correct, have until 1 year after the next election. The next election is in October, so they would have until October 2022 to continue in office. And the submissions I made to the SCA, and I make them again today, is that if someone is unqualified, it doesn't matter whether they've had on-the-job training during the period of illegality, they were still unqualified, and they don't fit the purpose of the act as it was then. So I understand the complexity of trying to fix a date and to deal with something with suspensions and retrospectivity. But all I can say in this case is that it would be in order for this court, despite Justice Jafta's questioning of me a moment ago, to say at any time that that act was null and void at the time. We are going to declare it to be null and void, but in fairness to the municipal managers in particular, they should leave their positions on the date of this order, the order that this court grants. That then satisfies the principle. As you can imagine, Justice Mudlanga, it's not these two municipal managers that are really in issue here. This is a problem of province-wide disagreeability. and the MEC has felt that it's important enough to try and get the principle right. It may be asked of this court to accept that this will never happen again, but as I've put up and as my learned friends have put up, there is a bill before Parliament which is on very similar lines. So the same requirement of qualifications is going to be present in the future. So it remains a live issue. It remains a governance issue for the province, and not so much getting rid of these two gentlemen. I don't know if I've answered your question, but
I won't belabor it. All I will say is, like Justice Jafra, I'm not sure that is a good analogy, because in all pay, we never let the ball drop. When it was about to drop, it would be kicked high up again. Again, when about to drop, it would be kicked high up again.
yes.
Here the ball has dropped, and what I'm asking you is, where exactly has it dropped? Has it dropped all the way back to when we granted the SAMU order, or did it drop on the day the period of suspension ended? That's what I was asking you. But as I say, I don't want us to
Yes, no, I'm going to take the same view that I gave to Justice Jafta and hope you accept it.
Yeah. Let me move on to another point. If I'm not mistaken, I think on the facts, it has been said that whatever it is that the MEC did, it was done after the period of, is it 14 days had elapsed?
Yeah, yes.
Whether it's asking for information or doing whatever else the MEC did.
That's correct.
Yes. Now, what are the legal implications of that? That is the fact of acting outside of the 14-day period.
Well, I think the argument that we have always put forward and was accepted by the High Court is that the 14 days doesn't refer necessarily to the bringing of proceedings. And it's a question of an interpretation of sub 8 of 54A. It says that if a person is appointed in contravention, within 14 days, the MEC must, after receiving the information provided for, take appropriate steps to enforce compliance, which may include an application to court. In
That's
other words,
exactly my point. Yes, I'm not even suggesting that it ought to have been proceedings. I'm saying whatever it was, we seem to be in agreement here that it was outside of the 14-day period.
It was outside, yes.
Whatever it might have been, or whatever it was, what are the implications of that?
Well,
nothing done, the 14-day period has elapsed. What does that mean in terms of what may still be done or what may not be done? Or what may never ever be done for that matter?
I understand the point, and I think that my learned friend is going to argue that because nothing was done within the 14 days, then you've lost your chance and you can't ever ask for anything. And I think if you look at the section as a whole, the section as a whole starts off by saying that if you appoint someone contrary to this section, the contract is null and void. And to then interpret sub 8 as giving the MEC 14 days to do something, otherwise she's lost her chance, means that something that is null and void becomes valid just because 14 days has gone past. In this particular case, I don't think it makes much difference, but I do mention it. This all happened over a Christmas holiday and then started early in January or late in January when everybody's offices are back to work. And I think that just shows that the 14 days was a guide and not a cutoff period. And that's, in fact, what I've argued in a number of these cases throughout. It was accepted, it's been accepted by the High Court in Pietermaritzburg and at least three other cases. And that's basically the argument that I have to persist with, that the 14 days doesn't provide a cutoff after which the MEC is non-suited or out of play, because that would negate the entire working of the section, whereas if you compare it to being null and void and then having to go and get a declaratory order that it is null and void, that shows how the section is supposed to be read. And that doesn't really show that the 14-day period is sacrosanct. My learned friend sent me a copy of the second version of the bill. And that second version of the bill has in it, not the first, not the one I sent up to the Constitutional Court as part of my additional materials. That one doesn't have this new section, but the second version of the bill, which is apparently the Portfolio Committee's, has the Portfolio Committee amendments in it. There is a subsection 10, and it says, if the MEC for local government fails to respond to the appointment process and outcome within the timeframes as contemplated in section 7B, or the minister fails to respond as contemplated in subsection 9, the appointment of the senior manager will be deemed to be in compliance with this act. Now, I mention that to show what section 54A didn't have. If it had something like that, I would be in serious trouble in relation to the 14 days. And perhaps I will be in serious trouble at some time in the future in relation to this, if it gets passed.
If you'll still be in the state attorney's good books.
Yes, I have to stay in their good books. That's quite true. But if and I merely mention this, I can't argue that this is going to be the law. I'm just saying that there are two versions of what is before Parliament, and eventually something will be passed, whether it has this in it or not. But this has its own problems, because the time frame as contemplated in section 7B is that the MEC must within 14 days submit a copy thereof to the minister. It has no reference to 54A8, the time frame in 8. So either the draftsman has missed that, or, and I merely mention these things because they all produce their own results. But the one thing that 54A as suspended didn't have was a consequence for the late bringing of anything, doing of anything. And as a result of that, because there is no consequence,